deprivation of liberty in non-international armed conflict. Who would believe they still exist? Non-international armed conflict, and they are even prevailing. And there is what is important for the Geneva Academy. There is a lot of interaction between international humanitarian law and international human rights law. And we have the author of this book here, Jelena Plamenac, who is an IHL expert in the group of experts on Libya of the UN Security Council. Before that, she worked as a manager of the Regional Resource Center for IHL. Strong point, one of her strong points in Beirut in Lebanon, and before that as a situation analyst at the office of the prosecutor of the International Criminal Court, and even before that the office of the prosecutor of the International Criminal Tribunal for the former Yugoslavia. But obviously, at least for me, the most important thing is that she is a graduate of the LLM of the Geneva Academy. And then she did what I like, at least with students. She didn't write immediately a doctoral thesis, but after some time, then she wrote this thesis and is a doctor of the Faculty of Law of the University of Geneva. Having been the supervisor, I'm obviously not impartial, but an impartial body, a panel of the American Society of International Law found this book very good and gave it the Lieber Prize of the American Society of International Law. So I believe that my very positive assessment of this book is apparently not totally partial. Now, the issue we speak about is, and here I think there is really something I will introduce obviously later, the other panelists, but I take the advantage of being the moderator, but also a panelist of first telling you what I think about it. And so it is quite unique because at least in IHL in Europe, sociological analysis by lawyers are very rare. And she bases the book on a sociological analysis of the actual practice of both armed groups and states concerning detention in non-international armed conflict. And she found that a lot of commonalities exist, some differences exist in the detention behaviors of warring parties, including states, non-state armed groups, and third-party states in extraterritorial, non-international armed conflict. Now, lawyers are fascinated by this issue, which is the question of detention in non-international armed conflict, because as you all know, nearly all, there's only one person in this room where I'm not absolutely sure that she knows. While this is very well regulated in international armed conflict, although we see also now that it is not better respected than in non-international armed conflict, in non-international armed conflict, lawyers are fascinated by the question of the interplay between humanitarian law and human rights law, precisely in non-international armed conflict, and many, including in this panel, have written on that, and Jelena has simply found in reality what you write about does not matter. And the big issue whether there's an inherent right to detain except for Anglo-Saxon countries in Afghanistan, simply does not matter, because governments deprive fighters, members of armed groups, of their liberty, claiming that they are criminals, and states therefore exploit and manipulate their own criminal law to detain fighters in most cases, while armed groups have rather a tendency to apply, without saying it too explicitly, by analogy, Geneva Convention 3, and detaining them as a kind of prisoners of war, and therefore considering that they do not need any legal basis, nor that they need to foresee a procedure, at least when it comes to government soldiers. Now, admittedly, although they consider government soldiers as POWs, it is not exactly that they treat them as POWs, but we see that even in international armed conflicts, POWs are not always treated as POWs, so we are not so astonished. They do not expect, you cannot expect that they explicitly invoke the Third Geneva Convention and have the two volumes of the ICSE commentary on Convention 3. But substantively, this is, and Jelena found that in her field research, what most groups, although there are some differences between religious groups and secular groups, and this is clearer for secular groups, while religious groups, anyway, they wouldn't even implicitly invoke international law, but rather their religious rules. And to discuss this, we have here a wonderful panel. First, online, and soon we will see him, Tim McCormick, who is a professor at the University of Tasmania. And this is one of the two reasons why he's online, and that this is far away, and the Geneva Academy is in favor of the protection of the environment. And he has a registered speech because we are in favor of humane treatment. And in Tasmania, if I understand correctly, it's something like 2 o'clock in the morning. And so we didn't want to wake him up, but he is also a pro bono advisor of the prosecutor of the International Criminal Court on war crimes. He has been professor at the University of Melbourne and has taught in Harvard, at the Hebrew University in Jerusalem, and at the US Naval War College. And then we have Jelena Page. We have two Jelenas, but tonight, most of the time when I say Jelena, I mean the author of this book. Yes. So Jelena Page, who was until very recently senior legal advisor of the International Committee of the Red Cross, dealing precisely with detention issues over the whole range of international, non-international armed conflict and outside armed conflict. And she has also been responsible for the ICSE project on, she would never call it that way, I call it an attempt to update international humanitarian law in certain fields, including on detention, and where she was particularly responsible, together with Switzerland, of enhancing respect for international humanitarian law. And as most of you in this room know, unfortunately, it did not yet succeed, but we should never lose hope in the field of international humanitarian law. Before that, she worked as a nearly pure human rights lawyer for the Lawyers Committee for Human Rights, now Human Rights First, and she has an LLM from Colombia. No, she is one of the few persons who didn't graduate from the Geneva. Because it didn't yet exist. I did not hide. Okay. And she has her law degree from the University of Belgrade. And finally, Nicolas Masson is a Swiss diplomat who is currently dealing with the relations with European countries, which is the most delicate thing for Switzerland. Obviously, you see the most important things. And that you will say, okay, but there's not a lot of detention, but he has worked a lot on detention because he worked for the ICC in the Middle East and then for the Center for Democratic Control of Armed Forces, ECAP, and finally for Staffan de Mistura and Geir Petersen, the special envoys for Syria. He was the holder of the most delicate file, which is detention. And he did that from Beirut. And now, very soon, he will move to New York. I don't even know whether it's because Switzerland wants to join the UN Security Council, and therefore it's better that someone who knows something about detention is there, or whether this is a normal change. And I suggest now we move to a presentation. Obviously, we have to deal with it in a particular way because as Tim McCormick has been registered, Tim will make his comments, while then I will ask a certain series of questions to my colleagues and accept what is interesting in her book to Jelena. But before that, I think the best thing would be if Jelena herself speaks about her book and explains us what she did and the main findings in this book. Please.
Thank you, Marco, for this wonderful introduction. I'm really pleased that you're all here. Thank you for coming. And thank you for being with me today, Jelena, Nicola, and Marco. I realized that you're all mentioned in my book by name. And Jelena especially cited multiple times as one of the key authorities in the field of detention in an international armed conflict. But obviously, my biggest thanks goes to Marco because he had to pull up with me for quite many years. I did write up this book and the entire research within a year time, but the contemplation process took a lot of years, I would say around 7 or so, and several attempts until I found the angle from which I wanted to analyze and research on detention in non-international armed conflict. I would say that the first time the idea came to my mind was late 2008. I was an intern at the International Criminal Tribunal for the former Yugoslavia. And one of my tasks at the time was to write a legal memo on legal rules of international humanitarian law applicable to detainee transfers in non-international armed conflicts. And as I was listening to my supervisor explaining to me that task, and as a fresh graduate, just exiting Marco's class, I knew that memo will be very, very short. We were at the time prosecuting 7 accused case, and one of the accused was a commander of a unit that captured a certain number of detainees and handed them over to another unit under different command. And these detainees were then executed. So we were identifying IHL rules that would give rise to his responsibility under international law. And that was the first time I realized the impact of the legal gap that exists in IHL for practical, for practitioners and for practical applicability of the law. And there were, I would say, two feelings that brought up the entire motivation to delve deeper into the research. The first one was the feeling of injustice that usually is the primary driver for me to do something. And I realized that simply persons affected by armed conflicts do not enjoy equal protection, but that would depend within which type of armed conflict they find themselves when it comes to detention. And second feeling was that the law was very weak and it lacked its power of enforcement in the courtroom. And I, at the time, contemplated that maybe, tackling the whole issue from the perspective which Marco referred to, and that is the relationship between IHL and human rights law, might be a possibility. And I soon realized that that practically would not resolve the entire issue. And there were two main elements missing from most of the initiatives that took place. One is that armed groups were excluded from most of the work that has been done on trying to regulate detention in an international armed conflict. And second was that very little was known on what was actually going on the ground when it comes to detention practices by both states and armed groups. So my curiosity as a researcher was, if I take off the curtain of legal doctrinal research, what will I find there? What is actually happening behind the scenes in reality? And as Marco said, it took several years for me as a practitioner to practice the law, to realize where are the gaps, and to contemplate until I fine-tuned and combined some of the old legal scholarship, where I found it useful, with a new methodological approach that combines legal doctrinal research with empirical research methods usually applied in social science. It was a remarkable research experience, obviously going to the field and talking to states, but also talking to members of armed groups like Hezbollah or Taliban, and hearing their views on detention and reasons why they detain people was fascinating. And I would say that this is how I also structured the book, where I first explained what I found for states and their practice in the 3 case studies I selected: Afghanistan, Syria, and Ukraine prior to 2018. And then I explained what I found in the practice of armed groups. And in the third part of the book, I compared them for similarities and divergences and explain where they actually are aligned, even if they would not want to admit, and then where simply there are differences between the two parties to the conflict. I would say that as a researcher, once I'm in the field, it's not only about the law, obviously. It's also about the factors that shape the regulatory framework. It's about politics, ideology, religion, and other societal factors that, in particular, armed groups do take into account, and that those factors shape, in a way, also rules that they apply in their detention practices. So some of these factors are also outlined in the book. So just as a start, I will share 3 key findings that are in this book. The first one is that irrespective of the status, whether state or a non-state armed group, parties to the conflict have the same security interests, and they detain for security reasons. The second key finding is that, and that's a pessimistic one, that parties to the conflict often, in most of the cases, disregard international humanitarian law as the applicable framework. They instead rely on their internal laws, or for states' domestic law. And finally, the third is that the deep polarization that exists in IHL rules applicable to non-international armed conflict between states and armed groups is also reflected in the field. This means, and what Marco said, that states detain members of armed groups primarily on the basis of domestic criminal codes and violations of domestic law, and they are not affording them belligerent immunity for participation in the hostilities, while armed groups, on the other hand, striving for sovereignty and statehood, do treat members of permanent armed forces similarly to prisoners of war. They would offer similar status to belligerent members of belligerent armed groups, except in very few cases. This is when it comes to the divergence in the polarization of the understanding of the two sides. However, when it comes to the detention of persons not taking direct part in the hostilities, but still posing a security threat to a party to the conflict, there are similarities between states and armed groups, and in particular secular armed groups. And the findings in this regard reveal a deep inadequacy of current internal rules by both states and armed groups. When it comes to states, domestic law, and I call this in the book double negation. So on one side, states will negate the applicability of international humanitarian law and treat the situation as a domestic affair that falls within their sovereign space and is regulated by domestic law. And the second negation is that they are not admitting inadequacy of domestic law that simply does not recognize security detention that can be longer than a pre-trial detention in view of trial, which should be not more than usually 72 or maximum 96 hours, as a possibility. So states do resort to behaviors that amount to human rights law violations with regard to detention cases of persons whom they want to maintain in detention under security reasons. They don't have sufficient evidence to bring them to trial, yet they also don't have domestic legal rules in order to maintain that detention. So as one of the possible solutions, I do offer a proposal on the minimum standards that should be applicable to the detention of persons not taking direct part in the hostilities. But I'm sure we will have plenty of time to talk about it later. I would maybe just stop here for now and continue the discussion.
Okay, thank you very much. Now perhaps we can hear what Tim McCormack would have told us if he was in the room.
To the Geneva Academy and also to Jelena, Plamenac, for the kind invitation for me to join you in Geneva tonight. I'm really sorry that I can't be there, and instead I'm doing the best I can short of physical presence to join you virtually from Hobart, Tasmania, deep down in the Southern Ocean, a long way away physically, but able to participate by this suboptimal virtual means. I'm really sorry that I'm not there to share the podium with some dear friends of many years. Sorry that I can't be with you, Marco, or with you, Nicholas, or the other Jelena, or Niels, all of whom I've known for many years and enjoyed my collaboration with you in many different forums. It's my loss that I can't be physically with you. But given that I can't, then of course I want to pass on my warmest congratulations to author Jelena. My plan was to bring my copy of the book, to schlep it all the way from Tasmania to Geneva to have it autographed in person. That'll have to wait until next time we catch up in person, Jelena. But of course, I would love to have been with you, especially because of all the great times that we shared together working in collaboration with each other on International Criminal Court Office of the Prosecutor projects, including many trips down to Geneva to meet with ICRC colleagues to talk through IHL issues that we were both grappling with. I thoroughly enjoyed our professional working relationship and the friendship that we developed alongside of that. And it's sad for me not to be able to be physically present to share in this wonderful moment with you. My warmest congratulations to you for the courage to decide to leave the ICC and finish off your PhD and to get it published and to get your message out into the academic and broader international community. And it comes as no surprise to me that your book has already been met with critical acclaim. Congratulations again on the award of the 2022 Francis Lieber Prize by the American Society of International Law for outstanding scholarship in IHL. I'm thrilled for you that your book has received that level of recognition so early on in its since its publication. And I want to thank you for the contribution that you've made in grappling with a challenging subject. And I know that the panel will be discussing some of the substantive issues that come out of the book. But I think the way that you've grappled with this ongoing, complex and difficult challenge of what legal framework applies to detention in non-international armed conflicts is truly admirable. I think the choice of 3 case studies, Afghanistan, Ukraine, and Syria, as a way of contextualizing the issue and drawing on practical experiences sets you up beautifully to be able to identify the disparate approaches to the question of detention but also to identify some of the similarities in the approach of parties to non-international armed conflicts in detaining individuals for security reasons. And the fact that you're able to identify very, very different approaches and the bases on which individuals are being held in detention, and then come to the concluding chapter and propose a model for a new legal regime to cover this complex area, I think is tremendous piece of work. Always practically oriented, but grounded in excellent scholarship and meticulous research, and beautifully written, if I might add, Jelena. So I'm really thrilled as editor-in-chief of the book series with Brill to include your volume in the series, not only because I consider you a dear friend, but also because I think the book makes such a great contribution to the literature. We have no book in the series on detention in non-international armed conflict prior to your volume, and I'm sure that not only with the award of Francis Lieber Prize, but with the substance that you deal with and the way in which you deal with it, this book will continue to receive acclaim, and your own reputation as a scholar and a researcher in the field will only grow with it. I hope you have a lovely time together. The celebration of the launch of a book can never be a negative experience. And yes, all the best for tonight's proceedings. I'll be fast asleep, I hope, between 2 a.m. and 4 a.m. our time. So I'll look forward to watching a recording of the session when I get the chance tomorrow or the day after, in the next few days. Thanks very much for having me. And I wish you all the best. Bye-bye.
Well, thank you so much to Tim. And I obviously agree with every word he said. And perhaps now I ask a neutral, if this is not an invective in the modern world, the neutral people in this room and panelists, what did you find particular and most interesting in this book? And perhaps we start with Jelena Page.
Thank you so much. I too would like to congratulate Jelena on the book and to sincerely also congratulate her on the Lieber Prize. This is a really big deal and I'm thrilled for you. And it is, of course, well deserved. So allow me to say that I'm not going to say anything new in this particular segment. The particularity of the book, as you said and as Marco has said, as Tim has said, is actually the fact that it's so much, field work went into it. And the fact that it addresses three contexts from a both state and non-state perspective and shows the laws, quote unquote, as well as the practice of, in particular, less familiar non-state armed groups. So the empirical research is absolutely astonishing. I also thought it was particular because it was very focused. It addressed grounds, process, and transfers. And I thought that rather than being all over the place, the fact that it focused on these three areas, which are, by the way, deficient in the law, as we know, was a good way to go. And then I also liked the policy recommendations, which are sober. And I used that word in the best meaning of the term, meaning they are based on the reality that was identified. Two things I found very interesting, even though I should probably have known them. One is the extent to which, in fact, state and non-state armed group practices mirror each other, both in terms of the lawlessness of the behavior on the one hand, and of the ad hoc nature of reactions to states in certain extraordinary circumstances, exceptional circumstances, in terms of scrambling to find a legal basis for detention or not. And then, of course, the ad hoc nature, which is more of a given for non-state armed groups. And another thing I also found really interesting and very useful as a way to approach thinking on this issue is Jelena's division of, if I may say, reasons of detention into three categories. One is the detention of those who belong to the opposing side, either the state side or the combatant side. I mean, that's sort of, we know that more or less. Then the second category was those who DPH directly participated in hostilities, but do not belong formally or otherwise to one of the warring parties. And then thirdly, those who have actually been detained for discriminatory or other nefarious reasons contrary to the law. And I thought that third category has been one which is particularly forgotten in discussions about detention, both by state and non-state actors in NIAC. So you're walking down the wrong road, you happen to be of the wrong ethnicity, you've done absolutely nothing and you may end up in. Voila. So I think with congratulations again, I'll end it there because we are meant to be short right now.
Okay, so I give the floor to, thank you, Jelena, to Nicolas Mas.
Thank you very much. With the caveat, thank you for your kind invitation, Jelena, and kind introduction, Marco. With the caveat that I'm not a lawyer, so I may say or use a few terms that may not be fully correct, but I think I read the book of Jelena at least twice, just precisely because I'm not a lawyer. I have to understand things very deeply, and I hope I have. Two things I found really impressive in the book. The first is the research. It's been mentioned, the 3 case studies, Ukraine, Afghanistan, and Syria. Since I know the Syrian case a little bit more than the 2 others, I was really impressed by the quality of the study of the Byzantine architecture of detention pre-2011 and post in Syria. And I think I can say you have definitely provided with this section in the book with the best English language description of the Syrian system that is to date available. So congratulations on this, and it's the result of your field work. I remember meeting you in Beirut just at the beginning of it. Years have passed, and I know it certainly took you ages to get to that conclusion. Yet the section I really most like, and that's on page 195, and that's what you call polycentric detention regimes. Mm-hmm. And I think this, the section emphasizes how some recent NICs have blurred the lines between what is government and what is non-state. I just wanted to make the point here, not to fall into the trap of only always opposing the 2 categories, and there's a state, and then there's non-state armed groups that are fighting against the state. And actually, some of the examples I've seen, and that's fighting not only Syria, some non-state armed groups actually support states, and they are actually created, or they are supported by states to actually do the state's jobs in certain areas where the state has no reach. And by doing that, they are given de facto the authority to detain, to arrest, and to detain the people under the categories that Jelena has just described. The major risk with this, and I've witnessed this, is that courts in non-international armed conflict states basically seek to escape their duty to protect detainees under their own laws, and by delegating this authority to de facto to non-state armed groups, an erosion takes place. Non-state armed groups don't feel bound by legal or procedural standards of internment, and this leads and opens the way for all sorts of abuses. This does not basically contest any of your conclusion. On the contrary, it supports, in my view, and I will explain it later, the importance of what you have pointed as a gap or as the need for a model or for a mechanism, even under that model, to encourage non-state actors to adopt behaviors and procedures that protect state image, dignity, and life, but also puts pressure on those states that protect them or have created them or need them to stay in power, to also continue to respect their own duties. Thank you.
Thank you very much. May I, in an unorthodox way, suggest that for my next question, you start already to answer first, which is what the law should be on non-international armed conflict related to detention by states. So we move now to, or not to the findings by Jelena, but rather to the question, what, at the end we will discuss how can we get that law, but what would it ideally be? Ideally, and as we are here also realistic, ideally but realistically be. What do you think? By states, we come then to armed non-state actors.
Thank you for the question. So, not being a lawyer, I've decided to answer the question rather from a political perspective. But first of all, I agree with what is in the book, if I understood it well. At the beginning of a conflict, of a non-international armed conflict, there is an erosion taking place, at least in Syria. I've seen it very clearly. The state starts using its own laws, and when it's not sufficient, it amends its own laws. It becomes even harsher from what the legal system in Syria was even before the war, which wasn't the easiest one. Detainees do not benefit from any procedures, any guarantees, any protection, may remain incommunicado for a very long time. And I am afraid to say this is still a good scenario, the worst case scenario being enforced disappearance or situations where detainees are to be basically to die. In the less worst scenario, there is this erosion taking place, and this early shift from the criminal justice and detention practices to something harsher basically has created a very deep rift, a very huge, let's say, problem within society. And this is where the political dimension of the need to enhance protection under existing or new models becomes important. Why? You've probably heard recently of the Syrian government's decision to proclaim an amnesty. And amnesty meaning by that the release of detainees under those early conflict laws, criminal or anti-terror procedures, or of people who are waiting for trial. So the Syrian government itself has described this step as reconciliation. Mm-hmm. And I find it very interesting because, in my view, this is an acknowledgement of how divisive and how huge the problem or the rift was created by the early decisions to adopt harsh legislation against detainees. Detention becoming staying at the core of the conflict. This is why it's mentioned in Resolution 2254, which you mentioned in your book. It is part of the peace process, of the ongoing peace process, the main part of it. Why? Because society is deeply shocked by what happened at the very years of the conflict. So as a result of that, 11 years later, this step, I think, may play its role in reconciliation, but for me, it's an acknowledgement of an early situation where, in the absence of clear understanding by the state itself of how it should behave to protect detainees' lives, in the absence of, let's say, reasonably clear understanding of what they should do, they may actually go down the path of very grave violations and abuses, which then lead to serious problems with their own societies. So my point would be that there is a political dimension in the model and the mechanism proposed, not only for protection and legal reasons, but also in terms of preparing from the beginning states to prepare for the post-conflict situation. So the less abuses are created at the beginning of the conflict, the easier it will be for them in the future to turn and exit out of this conflict.
Again, an update.
Thank you. So it's an ideal question, or idealistic question rather, and I think it needs to be addressed from the point of view of content and form. I mean, those two issues are relevant. In terms of content, I think it would be wonderful, ideally, if we were to have, a new legally binding instrument of some kind that would normatively regulate detention in non-international armed conflict. This would be an instrument that, in my view, would be primarily based on IHL, because we are dealing with armed conflict, after all, informed by human rights law to the extent relevant, and I would add feasible, because that would be an important consideration. If that were ever available, I think two questions would arise. I will just mention them. One is, in that scenario, could we envisage the same catalog of content rights applying to both traditional NIACs, in which a state fights non-state armed groups on its territory, and extraterritorial NIACs, where there's a lot more gaps, both in law and practice? And my sense would be yes, but I'm just flagging that it would be a challenge. My sense also is, despite what Marco said, that if some sort of content endeavor were to be undertaken, that the issue of legal basis for detention, would arise. Could it be swept under the carpet? Would it have to be addressed? I think states have different views on this. But it's really form which is the most difficult issue. So leaving aside idealism, I have to say that I think there is no chance whatsoever at this point in time for states to agree on developing detention rules for non-international armed conflict. I will just mention one or two things really. Of course, one is the ICRC project that took place between 2011 and 2017 related to a mandate the ICRC got from the International Conference of the Red Cross and Red Crescent in 2011 on strengthening detention in armed conflict with a particular focus on NIAC, which involved an enormous amount of work, involved 6 meetings, and involved reports to states, to the international conference, that then allowed work to continue at a higher level, if I may put it that way, meaning that states should now take a stronger role. 2011, 2015 was a consultation process, really led by the ICRC without any obligation for anyone. The idea was to move into more of a state-run procedure after 2015, and then when the first meeting took place in 2017, states could not agree on modalities of future work. And so it was suspended. And in that context, I would like to pay tribute to my colleague, Tilman Rodenhauser, who was there in the back from the ICRC, who was in charge of the detention track process from 2015 to 2017, and was there until the bitter end, meaning 2017, when the thing crashed. 2 reasons why it crashed. This is my personal view. Maybe Tilman would like to say something in the Q&A or afterwards. Is that on the one hand, you have states who have come out of extraterritorial detention, who had come out of it, who had court cases, before domestic tribunals, and were incredibly wary of any idea of putting something on paper in any shape or form. You had a group of states who needed for their own domestic legal reasons to be able to say, yes, there is a legal basis for detention, which is why this question would come up if anything ever came to pass. And then you had a vast majority of states, I hope Tilman agrees, that actually they don't recognize that they have either non-state armed groups or an IAC on their territory and call this terrorism and deal with it, as Jelena's book demonstrates, through completely inadequate criminal law. And the other, I can't think of a better organization, to be honest, better place than to deal with this issue than the ICRC from the state perspective, and it didn't work. And you know what the geopolitical atmosphere is like today. It's unlikely that it's going to happen, particularly as the focus is now on IAC and not at all on NIAC. So non-groups, what? I mean, it would probably be very difficult. And then the other process that took place as a result of, domestic political pressures was the Copenhagen process, in which the Danish government organized a group of states who worked a couple of years on something called the Copenhagen Guidelines on the Handling of Detainees in International Military Operations. The ICRC and other organized IOs were there in an observer status. And they devised, I think, something of a useful catalog of rules. Actually, the commentary is more interesting than the rules because the rules are sort of basic. But it also applies only to NIAC, but also only to international military operations, meaning extraterritorial occurrences. And I have to say that I'm not aware that it's gotten a lot of traction since adoption. It's quoted here and there mainly by Western states who were present, but it hasn't had a huge impact. And so before COVID, there was an attempt by the Australians, or it was being discussed at least by the Australian government in conjunction with the Danish government, to have some sort of second round of Copenhagen, possibly plus, in terms of participation discussions. But COVID happened in the meantime. Russia happened, Ukraine, and so I'm not aware that things are going anywhere. And I think politically it would be very difficult too. So on that unhappy note, on that sober note, I will end here.
And Jelena, what did you write, or do you have some, Jelena,
Plamenac. What did you write, or do you have some additional ideas to what you wrote on this issue of detention by states?
Yes.
What the law should be?
Well, I agree with both points that Nicola and Jelena brought. From the legal perspective, I am equally pessimistic as Jelena that there are prospects that states would regulate detention in an international armed conflict, primarily because this is an exclusive sovereign right that belongs to authorized law enforcement agencies that fall within the state control. And delegating that power to a non-state entity that tries to overcome the government is unrealistic to expect. But Nicola's point on the impact that diverse detention practices by states generate in terms of reconciliation in the society and the shock that citizens of a state experience when an armed conflict breaks out and extraordinary legislation is brought that would deprive them from most of their human rights. In Syria, for instance, they were stripped off only to the right to a lawyer of all the procedures that are out there. So from my perspective, I would say states need to work better on regulating emergency situations such as armed conflict already during peacetime. And I would say there are at least 3 qualities that such legislative process should have. First one, obviously, transparency. There needs to be a very transparent legislation that explains to people what is going to happen to them if there is a non-international armed conflict, and what are the grounds for detention, what are the procedural rules that would be applicable, even if it's a part of a domestic law. Second is there needs to be sufficient level of concreteness and tangible quality of the rules that would be applicable in such a deprivation of liberty. And finally, that there needs to be, that legislation should be very well embedded or placed in the existing legislation of a state that would be applicable in peacetime, because obviously procedural guarantees that would be applicable in criminal detention would be also, most of them, applicable in relation to security detention, and they should interrelate with the agencies, security agencies involved in detention, etc., in order to preserve that protective nature of the law and to mitigate the shock that the situation of armed conflict would have on local population when it comes to its security. And we all who experienced war in this room know very well that just the existence of it is already stressful. But not having legal certainty when I will be detained and what is going to happen to me is really it's a very, very stressful feeling, I would say. So overcoming that, or at least mitigating, it will always happen, but mitigating that impact on civilian population in times of non-international armed conflict through states doing better job in legislating or improving their policies. Executive policies is also an option. I would say that would be the way for one of the ways forward. And on substance, I agree with Jelena that IHL standards would make sense, especially on the grounds for detention.
Okay, well, perhaps a remark from my side. You also spoke about armed groups. We come back to that very shortly. And so I remain convinced that IHL of non-international armed conflict does not provide for a legal basis and should not provide for a legal basis of detention. This could be offered by domestic law, which creates some problems for extraterritorial armed conflicts, but this is not an excuse. The states must be able to create rules. If you want to detain people, you have to create rules on them. Admissible reasons and procedures should be specified. Also, thanks to the book by Jelena, I do not think that all detention with an access to the conflict should be regulated. Similarly, I'm very, like Jelena Page, I'm very tempted by these three different categories, and in particular the third we forget. Also, obviously, if we call the third category unlawful detention, then you cannot have a regulation of unlawful detention, but we can call it another way, and then it could work. Now, I think criminal detention must be regulated by domestic law and is regulated by domestic law. The main problem is enforcement, and your findings are that, which for me is good. I mean, you know, from a human rights point of view, this is good news that states do not want to claim that they can detain people outside the criminal procedure, but they say we detain people who have committed crimes, because then all the judicial guarantees by international law for trials are applicable, but the problem is they are not respected, and it is very largely a fiction. Therefore, probably we need administrative detention. Not all situations should be governed by the same rules. I agree that internal and extraterritorial armed conflicts probably need different rules. And I would also say we have to distinguish people, in particular fighters, who are arrested on the battlefield and elsewhere. And elsewhere, I insist you can apply normal human rights guarantees, habeas corpus, but not interpreted in a too sophisticated way. Let's come to the basis of habeas corpus procedures, which also corresponds allegedly to human rights, because the same must be regulated by IHL, yes, but we have no IHL on that. So somehow we have IHL in international armed conflict, but let us be frank, the procedure on how administrative detention is regulated, at least in the Geneva Conventions, is not so precise to solve all the problems, even if we want to, by analogy. But, and here comes the point, unrealistic rules don't protect anyone. When people are arrested, and this must be defined more specifically on the battlefield, then I have been convinced you cannot apply habeas corpus or something like that, because it inevitably, and some of my students know this story, I worked in a context where there was quite an independent judiciary, and the judiciary simply released nearly everyone who was brought before a court. And the military, I don't excuse it, but I understand it, they don't like that. And therefore, these people were executed or were secretly detained. And this is not what we want. And therefore, we have to find alternative ways which are realistic, but nevertheless guarantee at least the minimum that it must be someone else than the military who capture the person, who check whether that person is actually a member of the armed group. And let us now perhaps move the other way around, but I will ask you first. So perhaps we start with Jelena Page about what the law should be on NIAC-related detention by armed groups. You can also say exactly the same. Which would be the traditional answer if this is an idea?
No, I'm not going to say exactly the same, but I do want to make 2 points before that. One is that thank goodness we're not going to be dealing with state regulation of NIAC detention by states, because I mean there would be a mess. And already, for example, I don't agree, as Marco knows, on the legal basis issue. I'm also not sure that doing rules that would make a gradation between battlefield versus non-battlefield detainees as a matter of internment would be possible, because the legal standard is imperative reasons of security. You can either DPH and therefore fulfill that standard, but you can also do it, as Jelena's book shows, you know, in different ways, contribute without necessarily being a member of the armed forces. So, voila. So I'll just park it there, just to say that there would be, I think, lots of differences of opinion. On the point of what would be the law for NIAC-related detention by non-state armed groups, I would say the following. Again, content and form. In content, it would be a document primarily based on IHL, even more so, if you like, informed by human rights law, as I said before, to the extent relevant and feasible. As, again, this is a point of divergence, particularly in academia. I don't personally think that non-state armed groups have human rights obligations as a matter of law, and I would like, you know, well, that's a whole separate can of worms. As regards form, which is, I think, the more difficult issue, or would be the more difficult issue if one tried to do it, my sense is that one should really go for as regards form, ideally, to answer your question, it would be, again, some sort of binding treaty on both states and non-state armed groups. But for the reasons we mentioned, that's not going to happen. So the question that I think that really needs to be addressed is, should one simply disregard and put aside the state aspect of detention in NIAC and leave it as it is, and move towards some sort of discussion, examination, or development of rules related to detention in NIAC by non-state armed groups? My personal answer to that, because of the state side, which is difficult, would be yes. And my sense here would be that one would go. One should look at a possibly non-binding instrument. We can talk about that in the last series of questions. What would that entail? But I guess what I do want to say is that the ICRC, one thing I haven't mentioned is, as many people around this room know, in 2005 did procedural principles and safeguards for detention in armed conflict or other situations of violence, which basically tries to, stop up certain gaps as a matter of law and policy for all types of detention of non-POWs, everyone who's a non-POW. And the principles actually do say that they could contextually and should contextually apply to detention by non-state armed groups. Now, that hasn't happened a huge amount, but I think, and Jelena, thank you. You do make reference and build some of your own principles and proposals on that ICRC work. That's what's out there. Jelena's book is now out there. They're fairly similar in terms of, the normative framework, and it would certainly be along with the detention process documents that the ICRC undertook with states from 2011 to 2017. There is already a wealth of material out there. I guess my last point, and I just really need to say it, is that the issue of criminal detention in NIAC, I understand what Marco was saying, that it's very nice and good that states criminally detain people because they're committing crimes. 2 points. One is, as Jelena's book demonstrates, that type of criminal detention, one, is usually an abuse because it doesn't really lead anywhere. And then number two, let's say we did have ideal criminal justice systems and people were put away for simply, for reasons of criminal activity. So the question is, would you prefer an internment regime that lasts less and where you're released at the end of active hostilities when the war or armed conflict comes to a close? Or do you prefer actually being sent to jail for a reason related to the conflict, for, I don't know, whatever the national law would say, but it would be pretty severe, I should think. So if you're criminally prosecuted, you would stay in jail for a really long time, maybe longer than persons who would be, simply interned. And secondly, the problem with internment is that the problem is that with internment, and Marco, I know you know all of this, of course, is that you may very well consider present a security threat, but not be considered that there's sufficient criminal evidence to prosecute you criminally. And then what do? And then you go to the criminal abuse system that happens in practice. So there is a reason for internment in international law and conflict. There's a reason that AP2 mentions it. It is undeveloped, and I think internment is something with proper safeguards, that could be considered. And Marco, you yourself have kindly said that courts simply release people even on habeas grounds because they're intimidated in a lot of cases when members of non-state groups come before them. And the group's members come and sit in front of the court and go, we dare you to do this, etc. So there's a lot of work to be done, but I think working specifically on the non-state side and would be a way to go. I don't see any other way at the moment.
Nicola, on the one of the non-state side?
I pick on this. I think quoting Jelena, she says it's crucial to depart from a state-centered approach, which basically confirms what we just said. Again, going back to my initial argument of the somewhat artificial dichotomy between the non-state armed group and the state. In the conflicts I've witnessed, there were rarely non-state actors that actually did not have somewhere a connection to the state eventually. And those who do not have a connection to the state are those who are more difficult to deal with when it comes to discussing with them basically. Take ISIS, take Al-Qaeda, the others, at least in Syria, they had either a connection to Damascus or they had a connection to Turkey. And I mentioned this or to others. Or others, in the case of Hezbollah, for instance. Now, I mentioned this as a state, also to prove what you just said, is that engaging non-state armed groups in developing whatever legal instrument, or at least remind them of those basic procedures. I can give one example. The most important to me in my job was registering whomever you detain. And this was not me. So by the moment you register the person, you have the name, a family name, first name, date of birth, where's the family address, etc. This person exists. The non-existence of the person was the worst abuse ever, because they could not get in touch with their families did not know the whereabouts. In the end, even in the behavior of the state or of the non-state custodian in detention, if the person is not registered, basically this person is not the person. It can also be eliminated. So that was for me the first and basic one, but that's just an example. Bottom approach would be, if indeed we can engage some non-state actors, in the end, somewhere they are related to a state. So it can inspire a state, or at least very practically, state actors will very carefully look at what the RCRC, Geneva, or whoever else is doing with that non-state actor. A concrete example of that is the Astana platform, which was created in parallel to the UN peace efforts. It gathers together Russia, Turkey, and Iran, and the UN. That platform has somewhat created the category of state guarantor to the opposition. And by that, specifically Turkey was the guarantor of the opposition, and by being within the opposition, there were some non-state opposition groups. When we organized or when we facilitated detainee exchanges between the government of Syria on the one hand and those groups on the other hand, it was basically Russia and Turkey. It would never have happened if it had only been between that non-state actors, which means that states were looking very carefully at what non-state were learning, and non-state actors were learning from what we and the ICRC were promoting back then, which were very basic ICRC rules in which exchange of prisoner, registration, consent, avoiding non-refoulement, etc., etc. So there was a learning happening there. I'm not saying this can develop into a law or a mechanism, but it was interesting, and it was actually, I'm not saying it as the perfect scenario, it was actually working for those few people who were exchanging those data exchanges. So there is some glimpse of hope. And again, I would avoid too distinctively opposing a state and a non-state actor. Mm-hmm. Politically, in conflict, they are very often intertwined, and they learn from each other, for the best and for the worst, of course.
Yeah. You want me first? Well, no, I mean, by armed groups, I understand that in reality it is difficult, but perhaps I have also the perspective of a former ICSE delegate that to say I have to negotiate with the sponsoring state is a non-starter. I have to negotiate with the group. And when it comes to the group, I think we cannot oblige groups to conduct trials. And we cannot oblige them to legislate. But they must somehow, again, no perfectionism, must announce reasons and conduct on request a kind of third-party verification of admissibility, except on government soldiers. But the government soldiers must then really be treated like prisoners of war, and somehow this is foreseen by Article 3 Common, which encourages the parties to conclude an agreement, and why not encourage an armed group to make this through a unilateral declaration. And there I agree that then this regime prevails over any claimed applicability of human rights to an armed group. Now, obviously, if we see it this way, this implies abandoning the axiom that belligerents must be equal. But this can be justified by the fact, and here, to a certain extent, I agree with Jelena, that states are also bound by international human rights law. And the ICSD customary rule interpretation of ICSD customary rule 99 about what that means, the prohibition of arbitrary detention in non-international armed conflict, is anyway based upon state practice exclusively and on human rights law state practice. While I think it is important that in IHL parties are equal, I'm not shocked if the result of the interplay of humanitarian law and human rights law leads to the fact that armed groups are bound to other obligations. Obviously, the prisoner of war idea is I think when they detain government soldiers, this is not so shocking to have to deprive government soldiers of the normal guarantees. Why? Because it is normally easier to determine whether someone is a government soldier than whether someone is a member of an armed group. You have now any comment on the specific armed groups aspect?
I would maybe just shortly reflect on what you already said, and I fully agree on the perspective that it is more feasible to regulate detention by non-state armed groups than by states through binding or non-binding instruments. It's something that we can also discuss, but again, I'm coming back that there needs to be a certain quality of these rules in order for armed groups to actually accept them and incorporate them as a part of their internal laws and codes of conduct. What Marco is saying about the principle of belligerent equality is very important. And these rules should somehow preserve that principle. Obviously, it's unrealistic to say that it would be absolutely respected, because it only would regulate one side. And then this comes to the second quality of these rules being practical. And Jelena really nicely, and I quote her in my book, captured the essence of grounds for detention, imperative reasons of security, that it strikes a balance between the security needs of a party to the conflict and humanitarian needs, that it's only imperative exceptional measure of deprivation of liberty. And having such rules incorporated in that instrument would somehow mitigate the fact that instrument only regulates detention by armed groups. And then finally, rules need to be realistic. This means that if we have a tremendous range of organizational levels of armed groups and their capacity to implement, in particular, procedural guarantees, we have to be mindful of realistic nature of such rules. So imposing obligation of judicial review on an armed group wouldn't be that realistic. And I also argue that in my book, based on the findings from the field, not only that armed groups would not have such capacity in many instances, even states would have difficulties in finding sufficient number of lawyers to provide the defense and then a judicial review of detained persons. So keeping that in mind, I would say that it's the right way to go, of offering armed groups an instrument that they could incorporate or implement in their detention practices. And I fully agree with what Nicola said about the connections between non-state armed groups and states. This is very important to keep in mind, not only as allies, but what I found in practice is that states will exchange detainees with armed groups, even if they are belligerents. This is very important to keep in mind. And second, states do offer amnesties to armed groups, including for depriving unlawfully within their territory. So I would say these are some of the points that could be thought through when developing such instrument in terms of implementation and successes that they could generate on the ground.
Thank you. Now, obviously, all of you already spoke somehow, but perhaps Nicola less and I less about how can we obtain those rules. We find ideal or realistic ideal. I don't know, what do you think, Nicola? What are the chances to get rules? Because, okay, the proposal now, there seems to be a consensus, we need rules for armed groups, because that's easier, because states cannot, will less resist. I'm not sure that they will less resist. And the problem is, obviously, if you make rules for armed groups, you must ask armed groups what they think about it. And either they will give a hypocritical, wonderful theory, or what do we do if they say, okay, all these things we cannot do? Okay, then you have to start a long-term negotiation, probably group by group, to find the maximum they are ready to accept. But this leads then to an incredible fragmentation of international humanitarian law, and raises some problems with international criminal law, because, okay, if we say, I speak now as a former chair of the board of Geneva Code, if we encourage an armed group or say, yes, undertake to do this, and this is then seen by an international criminal tribunal as a war crime, that's slightly delicate. But probably realistic, and probably parts of international criminal law, when it comes to armed groups, is not realistic. Now, how can we get these rules? What do you think, brother?
It raises a lot of questions. For me, it's a question of what are the incentives you can give them? Why would you do this? And then I've read some literature besides my 2 readings of Jelena's books. There was someone saying, well, there could be a brownie point. We can give them statehood. They behave well, good detention, then they become a state. I think good detention management is an early sign of capability in the future to become a state or a quasi-state. At the other end, unfortunately, I've seen too many examples from Syria, Iraqi Kurds, Palestinians who've been doing quite an okay job in detention compared to others, and we're never getting stated because on that clear basis. So the other example you're given, don't do this because you're going to go to a tribunal. This is all externally formulated incentives, which may not, precisely in the case of an armed group, actually speak. Why? Because the reality is the little piece of land that they're actually managing. And what is there? There is a population. And it goes back to my early argument, which is we need to give them the internal incentive of giving them the examples. And there are many where mismanagement in internment, confinement at the beginning of conflict has actually created an incredible rift within society, which then is no longer managed. Too many tortured, missing, disappeared. Societies cannot accept that, cannot live with that burden. It's just impossible. Forgiveness cannot happen, and this is the recipe for the next conflict. So I would formulate incentives in that sense, not towards the external brownie points they can get from the international community or from statehood or anything, but from within their own society. And again, I believe in the bottom-up and constructive effect this can have on conglomeration that may result in statehood later. International community, I think, looking at it now as an ex-ICRC delegate, but now with the Swiss government, I think there is too little being done and too few organizations involved. And now I understand ICRC has this huge experience, probably does the job much better than the others, is followed by others, but there is an immense lack of knowledge that has transpired from ICRC's experience into other agencies. And I mean organizations, states that are interested in development, more in development than they are actually in law, institutional development, and criminal justice systems. And within those organizations that still do this or that do this a little bit, a few of them actually work with non-state actors. So I think a reason why and a few successes were reached there is that because it remains a small family of very specialized and good organizations, and that the outreach to others who actually do more development, criminal justice reform, etc., security sector reform, that outreach, for me, from my perspective, has been missing a little bit, and associating experiences there may have more impact from now.
I don't know, you already spoke in your previous answers somehow of the form, because that was the point of this, that you have something to add on now, purely the form of how could we get such rules?
So thank you, Marco. My sense is that it would we would be talking about a non-binding instrument. This instrument would not be negotiated by states for non-state armed groups because of the participation issue, because it's not going to happen, period. So my thinking sort of broadly on this is that I think it would be useful to start with some sort of initiative to develop principles, rules, if you like, on detention by non-state armed groups in a, conditionally speaking, in a private perspective, meaning ICRC, academics, civil society, and non-state armed groups. And I think it would be possible to identify, maybe Tumor will say a little more about this, non-state armed groups that may be willing to take part. We have technology today, so fortunately, they don't necessarily have to come to Geneva. You don't have the problem of having to travel there. A lot is avoided if you can bring them in through various technological means. So I think non-binding, private, I mean non-state effort, with groups that would need to be identified. And then two things could happen. One is that groups could be, this would be open for groups to associate themselves with. That's one way to go, I think. And then I know you said Brown influence were not terribly successful, and I completely agree with you. But for example, one can imagine that, you know, states that engage with these groups, they would have a tool, you know, to, when they go into and partner with non-state armed groups, which they do in their detention practice, they could have a baseline for engagement on improving the practices of that non-state armed group. And then such a document could also, if and when the opportunity arose, be a basis for developing a treaty if and when in the far future, you know, this were to happen. So a petit comité, you know, of interested organizations that would start examining the issue and then be able to produce a project proposal for somebody. And then, you know, it's the usual things that would happen. There would be a project lead or leads, obviously. There would be participants, purpose, how prescriptive, as you mentioned, Jelena, funding, timetable, etc. I would simply say that obviously the ICRC would have to be a participant in this, and then it would depend on who would take, you know, the lead for the petit comité. So I think that would be a realistic way to go, because I don't think binding is going to happen. And we have to associate groups, otherwise it really makes no sense. You know, it really makes no sense. And I think this type of what I call private effort, non-state endorsed effort, would allow a lot of hurdles to be, you know, overcome.
No. And obviously, the problem would remain that armed groups, in my experience, are very sensitive to unequal treatment with the government. So they will ask, okay, and what you are for the government, but there one can say, look, there are plenty of legal rules.
That's my, that was a point. Yeah. I forgot to say that exactly right.
Yeah. No. Do you want to add something on that then? Well, I would say, ideally, we would have some rules which are, yes, soft law, but nevertheless law. I wouldn't mix up policy and law, because it's a question, especially on detention, it's a question of legal obligations and not of saying, look, this is a better idea but that. But obviously, when negotiating with a group, it's clear that you don't speak about law. Now, generally, an idea is we could have an inspiration by other fields of international law. For instance, in international labor law, we have the core rules and principles of international labor law, which were adopted beside the 191 ILO conventions. And then I think there is a large consensus on the core rules and principles. And what they actually mean then, each state could and should undertake, at least to declare how it
sees that.
State or non-state?
No, I would say both, but simply separately. And they don't have to negotiate. Every addressee of these core principles of rules, I'm thinking outside the box in desperation because all the methods used until now didn't work. So why not come back to quite general rules on which everyone agrees, but in practice they would be adopted by states in an international forum. And then every state and every armed group clarifies what this means for that group. And this must be made public, which would have the advantage of the people concerned knowing what expects them. And this could then also create both by states and by armed groups, what is so important, the sense of ownership, because it's there. Obviously, the big disadvantage is it would lead to a fragmentation of international humanitarian law. And I must admit, there may be the risk that simply states don't play the game in the sense that they wouldn't adopt such rules or adopt rules which go into only their interest, even publicly, like saying terrorists and so on. So perhaps in the public there are some ideas. With this, finally, I open the discussion. We have someone, I see only one person who has a question on the ongoing detention and human rights violations of the Taliban, a state or a non-state armed group. I don't know what Jelena Plamenac thinks about that. Putting a particular the person asking the question puts an emphasis on basic human rights of women and the detention of those opposing the new restrictive laws on women. Did you find in your analysis any gender aspect?
When it comes to this particular issue, there was a gender aspect that was related to detention by jihadist armed groups. When they were applying some of the Quranic or interpreting some of the Quranic verses in relation to detention. And it is true that there is a difference made between female and male detainees. So from that perspective...
To the advantage or to the disadvantage of female detainees?
Disadvantage.
Right.
But also in terms of security threat profiling, it was in the advantage of females.
Yes.
So some of the armed groups, when assessing whether a person posed a security threat to them, perceiving a female as less or not having a possibility of having a combatant role or fighter role in the ranks of the belligerent side, they would be automatically put with children. And then males, on the other hand, even if they didn't have a role of a fighter, but they were able-bodied, would be automatically identified as a security threat and moved with high-profile security detainees.
And obviously, the remark of the person who asked this question is a good one and goes into your line and the distinction between state and non-state actors. Well, I would insist the Taliban are a state actor today, but except by Pakistan, not supported by many other states. But nevertheless, it shows the relativity because a lot of their practices are the same than before, and therefore distinct rules sound good and are legally logical, but in such a practical case are slightly artificial.
Yes, I agree.
So, anyone in the room having a question or a remark?
Thank you very much for the interesting discussion. I understand that your field research was mostly focused on armed groups that seek to either supplant the government or achieve some sort of sovereignty. And I was just wondering if either in your empirical work you looked at groups that don't necessarily seek to become a government or seek sovereign recognition, and not empirically, if sort of the same theoretical framework would be likely to apply something specific or particularly about the way in which those armed groups might treat members of the state's armed forces, whether you saw that as sort of bound up with that desire for recognition.
Mm-hmm. Thank you. I did look also into armed groups that were pro-government, meaning that they were affiliated with government armed forces, such as Hezbollah in Syria. And obviously, then there is no answer to your question because they were not detaining members of government armed forces. I haven't identified an armed group that didn't have an aspiration to achieve a certain goal. Perhaps that would not be statehood, but it would be some sort of autonomy or a benefit that would allow membership to operate in an autonomous way, which would mean basically that either they would negotiate their place within a larger alliance of armed groups, where they would not necessarily be in the control of the part of the territory, but they would be part of the decision-making process, and they would participate as auxiliary in governing part of the territory, or they would be larger armed groups that would have the capacity close to the state, and they would assume governance functions that would mimic a state. So obviously, when these armed groups detained members of government armed forces, the smaller ones that didn't have aspiration to statehood, they would be often handing over these members of armed groups to the larger alliance member, or the big brother, to say so, who would then have the capacity and the channels to negotiate the exchange with the state. Yeah, so there would be always some connection with achieving that goal, either indirectly through allies, or directly with the state.
Yes, Tillman now.
Hi, my name is Tillman. Mentioned before. But thanks a lot for the fascinating discussion, and congratulations to the books. I would have one question to you and maybe one to the panel. The one to you is, you mentioned 3 different groups: so captured soldiers, captured people who participate in hostilities, and others. So what's your recommendation on others, and who are these others that are detained? Mm-hmm. And if they are detained, what's your recommendation on procedures to get them out? And then the other question is, we've got a number of interesting proposals on what could be a way forward, an instrument. Did you consider such an instrument on the 3 things that you have in your book, kind of grounds, procedures, transport? Mm-hmm. Or would you actually envisage something larger, keeping in mind that, of course, the treatment of detainees and also their living conditions is quite extensively regulated? So how do you see that?
Mm-hmm. And the second question is for the whole panel or only for you?
If someone has a
start to answer.
Thank you. Excellent questions, and always. And again, Tillman, I'm really, really pleased you're with us today. So to answer your first question, as I mentioned at the beginning, the polarization between government and armed groups is reflected in the detention of members of the opposing side. And then there are persons, so obviously, and I think we agree here today that regulating detention of members of government armed forces and armed groups is not going to work because of this deep divergence between the two. Detention of persons directly participating in hostilities is just that simply they don't belong to the belligerent side. But again, there is a similarity of how they are detained with persons not taking direct part in the hostilities, but posing security threats. This means by knowledge or other qualities that person has. Let's say a person knows how to make a chemical bomb, even if they are not directly participating in hostilities, could be a serious security threat. So in my book, I do go with proposing an option of regulating detention of these persons in a single instrument that would be available to both states and armed groups, because this is where I found similarity. And obviously, I wanted to offer one package for all the belligerents out there, if they wanted an easy reference, how they could better detain, to say so. I focused on the three aspects of detention in an international armed conflict that are unregulated explicitly, but I would be 100% in favor of having instruments that merges and covers all the aspects of detention. So these three, obviously, and then repeating, and reproducing rules on treatment and detention conditions. If we are going to work on the project that Jelena mentioned as a regulatory initiative, we shouldn't compartmentalize the entire process. There should be one instrument. Some of the rules on treatment and conditions, it would not be difficult to simply incorporate in that instrument, and other aspects that the book addresses, the three ones, would require a process, a wider consultative process that would include armed groups. I do believe that it is important that their views are involved. I don't know if anyone wants to.
Perhaps I give the floor to, perhaps at the end we make a little round here.
Yeah.
Yes, please. Yeah.
And thank you very much for your presentation. I was wondering if there is a way of reconciling the possible criminal responsibility of a person executing a sentence who is not passed by a regularly constituted court, making it a war crime, and the lack of capacity of unknown state actors of complying with fair trial guarantees. And also, maybe, what is your opinion on what a regularly constituted court should mean for an armed group, if this is even possible? Thank you.
Want to do an answer to
Who wants to?
It was addressed. She's the star of the show.
Okay, I wanted to offer someone else. So the book doesn't cover issue of judicial guarantees. It does.
Rightly so, because the law is clear on that.
I would say it's very well developed.
While the problem is then implementation, a realistic implementation.
Yeah, obviously. When it comes to the notion of regularly constituted court, my colleagues really wrote fantastic pieces and studies on this.
Mm-hmm.
And there is recently a published book on rebel courts that really deeply analyzes this subject. I do analyze the practice of armed groups and the role of their courts in enforcing procedural guarantees, and in particular, the initial review of the lawfulness of detention. If you ask me as a lawyer, actual lawyer, if I would be looking into a war crime in my previous work at the ICC, then that war crime would apply to both states and armed groups. And regularly constituted would really depend on a particular context and how it was constituted under the armed groups' internal laws.
We have a very related question online from Niccolo Pons, who is a former academy student, and asks, he informs us, which I didn't know, that the pre-trial judge of the Kosovo Specialist Chambers last year found that under customary law or conventional IHL in 1998, there was no legal basis for detention in Anaya. And he mentions that this leads to a discrimination between armed groups and states, because states obviously can create the legal basis while armed groups can't create the legal basis. I would say, well, the problem is, why do they need a legal basis? Who says you need a legal basis for detention? Human rights law. And if armed groups are not bound by human rights law, they don't need a legal basis. But the question is whether findings of international tribunals on these matters are useful towards a codification of possible future law or for such an exercise. What do you think? Be frank. He is far away in The Hague, and he will not be offended if you simply say no, not useful.
I personally think that I'm aware, thanks to Jelena, the other Jelena, of the Kosovo Specialist Chamber's decisions, and I have to confess that my sense was that the chamber overreached a little bit in saying that there's a war crime of unlawful confinement in Naya.
Yeah.
Arbitrary detention.
Arbitrary detention, meaning, the IHL equivalent would be unlawful confinement. And one or two sentences, they actually use the words interchangeably. So I think that's going, a little bit too far. I think that any process that would take place to develop certain principles for detention would need to focus on unlawful confinement so that it could serve a criminal law purpose eventually. But I think at the moment, the chamber's decision is a little too lege ferenda, in my view. And I thought, honestly, that the reasoning was rather thin in terms of how they got to the conclusion that unlawful, arbitrary detention is a war crime in non-international conflict. If I may just, Marco, because I know there are two questions here. To graduate students, is just to say that when I suggested a process, for going forward, I didn't intend my sense, and this was really just thinking out loud, for states to be involved in this process initially, because of all the huge political and other issues that would come into play if they were involved. This would be, a civil society, ICRC, academia thing that could then, with the participation of non-state firms, that would then could be open to states, of course, for consultation in later phases, et cetera. But the idea would really be to, do something without those political considerations hanging over, particularly of those states who just reject the full idea that there could be any type of detention by non-state groups in Naya. So the equality of belligerents, in my view, issue would apply if we were dealing with binding law, but we're not dealing with binding law here. And that would take care of one thing. And then the other thing would be that we wouldn't have to get bogged down with certain issues that we would have to get bogged down with if states were involved and if it were legally binding. So that's what I meant by a private exercise, just start small and then have a group consider all the issues, then bring in the non-state, maybe do a draft, even if you like, and then bring in the non-state-owned groups then possibly do consultations with states, because it is a fact as well that certain states are incredibly interested in dealing with non-state armed group detention for those who have dealt with extraterritorial, conflict, who have been actors in extraterritorial and whose members may have been detained by non-state armed groups. So it's not like everybody's against it. There would be some allies, but not in any formal way. There could be state experts in their private capacity who could comment on the document eventually. But I think a lot of issues could be avoided if this was kept within, as I said, an exercise that groups would be involved in and they could later subscribe to if they want to, or states could use. I'm sorry to repeat myself, I'm not sure I was clear, but where states could then use this to engage with them. And one could even imagine this going to some, one thinks of the MRN mechanism. If an armed group hasn't subscribed to this thing, if it hasn't undertaken anything, then, the sky's the limit. You could think of ways of enforcement as well, about non-binding nature.
Thank you very much. Perhaps I take the last two questions and then we wrap up and answer those questions and make, if necessary, any remarks. Yes, who had the two. So,
mine a very practical question. So regarding the, also thank you very much for the presentation, it was super interesting. Regarding the development of an instrument or the idea of engaging the different stakeholders, how would that acknowledge the difference between the different types of armed groups and different capabilities and like development of the armed groups, both in the discussions and in the final outcome? Like how flexible could an instrument or a document should be in order to acknowledge the different types of armed groups, and would the engagement and the consultations would involve like the most developed armed groups, or would it go to the different levels?
Again, my understanding from your presentations that you mainly focused on detention of opposing parties, but I think that the dynamics within our groups are also quite interesting. So I was wondering what is your insight of detention of members of the own armed, like of fellow members of the armed group, and especially also the consideration of the command responsibility paradox and the whole thing that either you punish it or you're punished because you didn't punish.
Thank you.
Jelena?
I will briefly answer your practical question on the quality of the rules in terms of their
level of organization.
Yeah, or applicability to different levels of organization of armed groups. As I mentioned already, there needs to be a certain minimum. And I also say that in my book, that if an armed group is unable to comply with the minimum rules, it should refrain from detaining at first place. And this is why I developed the idea of polycentric governance systems, or where smaller armed groups would operate together with the larger allies and detain through them, or delegate that function to those armed groups that would have the capacity to comply with the minimum. In my proposal, I did find, and what we already referred here, to IHL rules are already applicable in international armed conflicts, such as the grounds for detention, imperative reasons of security, such as the core procedural guarantees already found in IHL of international armed conflict as useful and applicable in cases of armed groups that would be able to comply with it. And I would say that's the minimum. When it comes to your question about disciplinary detention, I was not focusing on the subject of enforcing IHL within own armed group. But I did accidentally come across some of the examples, and I did find that armed groups do detain own members for the reasons of imposing discipline, not for not complying with IHL. As I mentioned at the beginning, parties to the conflict disregard usually IHL as applicable rule, and they certainly do not see it through the lens of criminal law and command responsibility, but they have their own codes of conduct and internal laws. And if a member of an armed group violates them, then as a disciplinary measure, there would be a detention involved.
Last word, Nicolas.
I have one word on this question of how minimal the standards should be. And again, saying that in this, we shouldn't take it for granted that the armed group is less sophisticated and then it needs minimum standards. Some states have, let's say, disappointed me in how minimal they needed a set of standards to actually understand what to really do in Plamenac situations to protect detainees. So to remain basic is not only to make sure that all the armed groups can come together, understand and make it, but applies also to states. Also, one of the reasons is that states are not monolithic. And in detention, in conflict situations, suddenly you have one agency that may stick to its practices, which may be more or less restrictive, but may differ usually from another agency, state agency, like the intelligence on one hand, the military on the other. When it comes to a conflict, and suddenly all these people come together with different detention cultures. And I see a need to basically, again, from a bottom-up perspective, work on very minimum standards, also to teach or to convince states that in such situations, they should apply at least the minimum. I have one topic that I really wanted to I don't want to be long, but it has been mentioned in this gender. And this is why I also want to make a link with what I was saying before. All this is super important, but the link with the rest of what is happening outside detention, even in Plamenac, is important, and I think has to be linked in all initiatives. My example on gender is the following. The great majority, in Syria at least, of people detained were men, and the great majority of people suffering were women. Twice. Because the men was not there, that's the emotional side, but because the laws were not adapting to the detention of the husband was detained, and hence the law for the woman was she cannot inherit, she cannot work, she cannot earn money, etc. That's why I think this, I know it's pushing the debate a bit far, but never to lose perspective on the huge suffering that situation causes for the entire society around detainees, around detention, A, and B, which speaks for me as an optimistic for continuing efforts to actually develop these rules. Because in the absence of those efforts, we just give up and we just not only accept that detainees can disappear or can be tortured, etc., but also that all the families around them for generations and generations won't have answers and won't have any solutions to that. And it creates any conflict almost automatically.
Thank you. No, I think that's Jelena.
I really don't have anything I'd like to add. I've spoken enough, I think, except to say that I'm really happy to have been invited, and I thought it was a fascinating discussion. And thank you to the Academy and to Jelena for having us.
Thank you, Jelena, for your book. For those who took the floor and for those who didn't take the floor, because otherwise I would have had a difficult task. Just two very short things. I agree with you that we cannot let the states off the hook. We have also to deal with the states, and there can be hope. Now there are so many humanitarian declarations concerning Ukraine, that perhaps this is a game changer, that next time we say, okay, you declared this concerning Ukraine in an international conflict, so apparently you are ready to have more humanitarian rules. And then I very much regret my former students, Nicola Pons, to be rude, but I think international criminal tribunals do not helpfully contribute in this field, because simply their standards come 7 years later about something which most of the time they request parties to do things which during the armed conflict is unfortunately not realistic. And then we end up with even greater dichotomy between what tribunals say is the law and what actually happens in reality. Okay, so thank you so much.